Hey there, and welcome. Whether you're an employee, a manager, or you're just a little curious, the world of UK employment law can feel like a total maze. But don't you worry, in the next few minutes, we're going to give you the map. And the very first landmark we need to find, well, it's the most important one of all.
Okay, first things first, we have to figure out the most fundamental question there is. Are you an employee or are you a self-employed contractor? Because honestly, the answer to this one question determines pretty much everything that comes next. We're talking holiday pay, pensions, even your rights if you're ever let go.
So how does the law figure out your status? Well, you can think of it like a balancing act. An employee is usually told what to do, how to do it, and when. You know, they're part of the team, they don't carry the financial risk, and they have to do the work themselves. A contractor, on the other hand, has way more control. They're basically their own business, and often they can even send someone else to do the job for them.
And this is the part you absolutely have to remember. You can slap whatever label you want on a piece of paper, but a court will always look past that. They're going to dig into the day-to-day reality of how you actually work. So what you do is so much more important than what your contract says you are. All right, so once we know what you are, the next big piece of the puzzle is your contract. This is the official rulebook for your entire working relationship. So let's break down what it's really made of. You know, a lot of people think a contract has to be this long, formal document that you sign on your first day. But legally, a binding agreement is made the second you accept that job offer. It could be totally verbal, though let's be honest, having it in writing is always the smarter move.
That rulebook is actually a mix of a few different things. You've got express terms, that's the stuff you specifically agree to, like your pay. Then you have implied terms, which are things the law just assumes are part of the deal, like a basic level of trust. And finally, you can have incorporated terms, which pull in rules from other places, like the company handbook.
It is so important to remember that this contract is a two-way street. It's not all one-sided. Your employer has duties to you, like paying you on time and making sure you're safe. But you also have duties to them, like following reasonable instructions and generally acting with care. It's all about a balance of responsibilities. Okay, let's tackle what can be one of the most stressful parts of any job, when it all comes to an end. How a job can be terminated is covered by a really strict set of rules, so let's get them straight. The most common way a job ends is simply by one person giving notice to the other. The length of that notice is either in your contract or set by the law. Now, sometimes an employer might offer you a payment in lieu of notice, or PILON. That just means they pay you for your notice period, but you get to leave right away. But as you can imagine, not all endings are that clean-cut. Let's look at two very different situations. Summary dismissal is when the employer fires you on the spot for some really serious misconduct. Constructive dismissal, on the other hand, is the total opposite. It's when you, the employee, feel forced to resign because your employer's behavior has just become completely unacceptable. Now, this is where so many people get tripped up, so let's make this crystal clear. Wrongful dismissal is all about a breach of your contract. It's basically about not getting the right notice pay. Unfair dismissal is about a breach of your legal rights. It asks whether your employer had a fair reason and followed a fair process. They are two totally different legal claims. So what actually counts as a fair reason? Well, legally, it usually has to fit into one of a few main boxes, like your conduct, your ability to do the job, or redundancy. But here's the kicker. Having a fair reason is only half the battle. The employer also has to follow a fair procedure. And this is what that fair procedure looks like in practice. An employer can't just wake up one day and decide to fire someone. Nope, they have to investigate properly, tell you exactly what the issues are in writing, hold a formal meeting, and give you the right to appeal whatever they decide. Every single one of these steps is vital for that dismissal to be considered legally fair. Now, if you feel like you've been unfairly dismissed, you have got to move fast. This number on the screen is absolutely critical. You have a very, very strict time limit. It's 3 months less 1 day from when your job ends to start a claim. If you miss that deadline, you've likely lost your right to claim forever. All right, finally, let's zoom in on the special case of redundancy. This isn't about anything you've done wrong. This is all about when the job itself just disappears. And yeah, you guessed it, this process has its own strict set of rules. So what is a redundancy in legal terms? Well, it's a very specific thing. It's when a business simply needs fewer people to do a certain type of work. It is not a catch-all excuse to get rid of someone. There has to be a real, genuine business reason driving it. And just like with a disciplinary issue, making someone redundant means following a fair process. This involves actually talking to staff in a meaningful way, using fair and objective reasons to decide who is at risk, and even looking for other jobs for them within the company. It's a detailed procedure that's all designed to make sure things are done fairly.
So the main thing to take away here is this. For a redundancy to be legal, it needs two things to be true. One, the reason for it has to be real. The job genuinely isn't needed anymore. And two, the entire process the employer follows has to be fair from the very beginning to the very end. Wow, we have covered a lot in a really short amount of time, from figuring out your status to understanding your contract and getting to grips with the rules around dismissal and redundancy. We've basically given you the essential rulebook. So the final question is really for you. How does your own workplace measure up?